My name is Keith Bybee, and I direct the Institute for the Study of Judiciary, Politics, and the Media here at Syracuse University. And every spring, we stage a lecture series on law, politics, and the media. It's associated with Law, Politics, and Media course, and is co-sponsored by the Tully Free Speech Center, which is headed up by this dashing young fellow to my right, Roy Gutterman. In this speaker series, we bring out a number of practitioners from law, politics, and media who address topics at the intersection of these fields. And we encourage these speakers to speak in a way that does cross boundaries between what might be thought of as different silos sometimes. And today we are fortunate enough to have somebody who we didn't have to encourage, but actually does as part of their work, thinks about law and media every day. Our speaker is James Haggerty, who's an attorney and litigation communications consultant. He is author of the book In the Court of Public Opinion, Winning Strategies for Litigation Communications, which was published most recently in its second edition in 2009 by the American Bar Association. He is the owner of the PR Consulting Group, which is a quite well-known litigation public relations firm that has worked on communications aspects of some very prominent cases, including the largest class action suit ever filed against the United States government, the largest single-family Holocaust restitution claim in history, and largest patent case in history, and the Toyota sudden acceleration cases. Jim is known to us here at Syracuse University in the College of Law. We've had him speak, but he's not known just to us. The New York Observer has noted that his work helps even up the odds. The Washington Post has called Jim an expert on media strategies in high-profile cases. And the Financial Times has praised his book, In the Court of Public Opinion, as the perfect handbook for this age. Not limited to litigation, by the way. You can organize your life around this book's teachings, evidently. In any case, Jim is going to speak to us today as our usual practice. He will talk for about 30-40 minutes, and then we'll have an opportunity for question and answer. And at 5 o'clock promptly, we will break for a small reception where we can continue the conversation on a more informal basis. Please join me in welcoming Jim Haggerty.
Thank you, Professor, for that wonderful and well-written introduction. Yes. We joke because every year I send him my bio, and I'm always amazed at how well I sound on paper. Here's hoping I sound as good in the classroom. You know, it's a great pleasure to be here because this is an area that, and this institute and the work of the institute, is exactly the type of thing I do every day for a living, which is litigation communications or litigation public relations. And I'm always happy to present here on that topic, and I've been back now. This is actually the third time I've come up for the day, and I've spent the day, you know, meeting with students and then lecturing here as part of the series. You know, my mother would tell me that it's always good to be invited back somewhere, because it means at least some of what you're saying is of interest. But I'm also remembered of something she also said, that guests are a bit like fish. After 3 days, they begin to stink. And so hopefully I don't stink on this third visit to the Institute. The work I do, there's always a lot of misconception and confusion about litigation communications, which exists somewhere in between the practice of law and the traditional practice of public relations as people normally think about it. You know, there's this perception that what we do is we write press releases. You know, we arrange press conferences, and we certainly do all that, but that's a small part of what we do. You know, and it's important, I think, to look at things from a more strategic and a more theoretical level every once in a while, because that's how you get really good at what you do. And I can tell you that that is as true for someone in the media and someone practicing as a lawyer or someone in the PR field like I am. you can get so caught up on the day-to-day nuts and bolts of what you're doing that you don't think about the big picture. And I must commend the university, Syracuse, and this College of Law in conjunction with the other schools, because that's exactly what you're doing here in a way that a lot of law schools don't. You know, and they really don't look at all of the extrajudicial forces that affect the way we administer justice. And I think that's something that is commendable, because there's this notion that law somehow comes down from the heavens and is delivered to judges in some sort of cathedral. And I think that is absolutely not the case. And some of what I'm going to talk about today are the extrajudicial forces that affect the administration of justice and the resolution of legal disputes, because they're not the same thing, and that's something I'm going to talk about as well. A challenge, as always, is I could speak for hours on this stuff. There's so many war stories. There's so many facets of what we do. There's so many jumping off points for discussion. And I always use that to make the point that part of the difficulty in communicating any message is distilling reams of paper and facts and issues into a message that is receivable by your audience. In dealing with lawyers, and as you know, I'm a lawyer by background, but dealing with lawyers on a day-to-day basis, I always tell them that it is much harder to communicate your message in 1,000 words than it is in 10,000 words. And it's much harder to do it in 100 words than 1,000. And it's even harder to do it in 10 words or less that you really need, and that's proverbial, 10 words or less. But it's what you really need to communicate in this modern age. We're in the, I think it's 146 characters in a Twitter post. You know, in this age of the internet and social media and new forms of communication, communicating complex messages within that format is very hard. I mean, particularly when lawyers, they're used to communicating 10,000 words at a time. That's their sweet spot. That's what they do. Really looking at everything that goes on in the information age and trying to fit it with everything that goes on in litigation. The hundreds of issues, the thousands of documents, you know, the sometimes millions of documents that are produced in discovery, the pleadings and the arguments, and getting them to meet in the center somewhere so that everyone can understand what's happening in a legal dispute. You know, that's really the essence of what we do. You know, and you know, there's a sense that you know, the PR people are spin doctors. That we spend our day manipulating the media and massaging the truth for our own, I suppose, devious ends. And I can tell you that's absolutely not what happens. You know, the spin is used as a pejorative, I guess. But, you know, bending the truth has precious little to do with the work I do every day. And I often say that no matter how good a spin doctor is, you know, if you bend the truth too much, it breaks. And it's hard to believe sometimes that a good PR practitioner begins with the truth. You know, it's the old lipstick on a pig phrase that became quite common. You know, you can only dress something up so much. And truth is at the core of what we do. The problem is the truth in a legal matter is contained in millions of documents. And I believe this is important, you know. I believe that putting, you know, the information that you get in a legal dispute in a form that can be understood and used by various audiences, including the media, to form perceptions about the case, is vitally important to the resolution of legal disputes. And ultimately, I believe that it has an enormous amount to do with the administration of what is called justice in its loftiest concept. Look, I think that what happens in the court of public opinion can have as great an impact on this elusive concept of justice as anything that happens in the court of law. And, you know, I realize that's a bold statement, and hopefully by the end of this talk, I've convinced you to a certain extent. And so We do spend part of our time writing press releases, arranging press conferences, putting people on, 60 Minutes, or putting them on a shout fest on one of the cable networks to defend their position. But that's really only a small part of what we do. I mean, most of what we do in this field is more nuanced. It's really advising on the public implications of everything that happens in the legal context. Everything a litigant does sends a message. Every way a litigant acts affects the perception of the issues at the core of any lawsuit. And everything is coming together in a very real way. And I'll tell you that I certainly know a lot of high-profile lawyers. And they tell me that often they're called in not for their legal acumen, necessarily, but for their ability to handle all of these extrajudicial forces, including the media. In fact, a particular lawyer I know, Mark Lanier, who's handled a lot of high-profile plaintiffs' cases, including the Merck Vioxx case, he sometimes gets hired specifically for that. Another lawyer who often gets hired for that purpose, and this is something we discussed at lunch, is David Boies, probably the most famous lawyer in the country. He's the lawyer from Bush v. Gore. He's the lawyer from the Microsoft antitrust trial. He's most recently been involved in the California same-sex lawsuits. And he was hired, actually, in the past 2 weeks to work on behalf of the NFL owners in the dispute with the players, which is a case going on. And in fact, there's a hearing today on that case. In my estimation, a lot of times when he's brought into a case, it's purely for the public impact, purely for the impact that it has on various public audiences. He's probably, he's the most brilliant litigator in the country, but even the most brilliant litigator can't get up to speed in 2 weeks on all the issues involved in a case. And by the way, when he's working on 4 or 5 other cases equally as high profile. I think the NFL hired him to send a message to the players, to send a message to the media, to send a message to perhaps even the judge, the importance of the case and the fact that they're going to pull out the big guns to win this. The fact of the matter is when David Boies speaks, people listen. And that can have an enormous impact on the way the case is perceived going forward. And I'll tell you that in my work, a client of mine actually hired David Boies specifically for that purpose a couple of years ago. It was 2 German corporations involved in litigation, both in the U.S. and in Germany. And they hired Mr. Boies specifically to send a message to the other German corporation that they were willing to fight this thing out to the end. And you know what? It worked. So there's this enormous integration of legal affairs, public affairs, policy, and public relations. And it's really just growing. And, it does sort of offend the traditional sensibilities, I think, at times. Because the fact of the matter is we do have this view of judicial processes as something that occurs on a lofty Mount Olympus. But the fact of the matter is everyone is influenced by everything they see and their culmination of their life experiences before they get to the role of arbiter of justice or resolution or the resolution of disputes. And I'll give you another example why it's so important. Statistics show that 95 to 98% of all cases settle. There never is a judicial resolution. These things are resolved at the settlement table. And so what you have is that there's 2 implications of that. One is the fact that there never is an official determination at the resolution of a case in the civil context. Even in the criminal context, I'll tell you that most cases are pled out. But in the civil context, most cases, you never get to that ultimate resolution of who is right and who is wrong. So the ultimate determinant of who is right and who is wrong is the court of public opinion. But on a more practical level, if most cases settle, by the time you get to the settlement table, if a party has been beaten up for weeks or months in the media and before other public audiences, they're going to have a very different approach to settling a case and a very different number that they're going to settle the case at. You know, conversely, if the party has been holding their own, if on the plaintiff's side they've been really scoring their points and making it known why this is important, why it's so harmful what the corporation did, or on the defense side, if the defense has shown that they can answer the plaintiff's arguments, that's going to change the ultimate resolution of that dispute at the settlement table. And so there's all these practical aspects of real-world litigation that go into the work that I do and the impact of public perception on litigation and other forms of dispute resolution. And it's interesting. I think there's something at the core here that I'd like to talk about that doesn't get taught in law school and doesn't really get thought much about in the popular discourse, and that's the cost-benefit analysis. In every lawsuit, whether you're a plaintiff or defendant, a prosecutor or legislator, a district attorney, whether you're an individual or the largest multinational corporation, there is a discretionary aspect to what you do. Every litigant does a cost-benefit analysis before undertaking an effort to assert their legal rights or undertaking a defense of those legal rights. That is, they think, what will the cost of this proceeding be? You know, whether you have a meritorious claim or not, litigants all begin with, what will the cost of prosecuting or defending this claim be? How hard should I fight? What resources should I devote to the effort? If you're a corporation, how big a priority is the litigation to your business goals? Are you going to throw your best people at it? Are you going to settle it quickly? Are you going to go through the motions of litigating the case and you know, all the time thinking about the fact that ultimately you are going to settle? It's amazing to me, in my business, to say no comment is a no-no. You know, no comment inevitably means you're probably guilty when people read that. But there's a new one that corporations and defendants come out with nowadays that is, you know, we think this is baseless and we will defend this action vigorously. As if a defendant would come out and say, no, we think there's a lot to this and, you know, we're not going to try very hard to defend it. You know, the reality is you always say that, and in a way that those sorts of cliches, I think, often work against you. But really, and what any litigant is thinking is, how long am I going to go through the motions on this before settling, or is this something worth fighting? On the plaintiff's side, there are similar considerations. How much will it cost to ensure my rights are protected? How hard is the other side going to fight? How will we benefit if we win? These are the practical aspects that go into every lawsuit before any decision's made. I mean, for a more cynical view of plaintiffs' lawyers, quite frankly, there's another calculation, which is this going to generate the type of return on investment that I need to keep my plaintiff's firm going, buy my new boat, you know, my new private jet? That goes into the calculation as well. And so it's not just defendants or big corporations that are very pragmatic about legal rights. And any plaintiff's lawyer will tell you that the first thing they do when hearing about a case is consider the economic impact and whether they can put the resources towards it to deliver the desired result. So part of this calculation includes, what will all of this do to my reputation? Is it worth proceeding and defending my rights or asserting my rights? What are the risks? You know, if you're a public company, what will the investors think? What will the market think? You know, what will it do to my stock price? And then finally, what can we do to minimize the risks? And how can we incorporate that risk minimization into our legal strategy? And that's where the work that I do comes in. You know, and all of this informs the tactics, the press releases, the press conferences, the media stories. You know, it's not as simple as writing a press release, you know, putting together a media list and shooting it out to 10,000 recipients. You know, It is my hope that can be edited out of the video of this. I just hope that wasn't Charlie Sheen calling about his latest case. Yes, exactly. And I will say as an aside that I mentioned this at lunch, that an occupational hazard of the business that I'm in is that every time Charlie Sheen files a lawsuit or Lindsay Lohan gets arrested, a family member of mine emails me to say, you know, they need your help. Why don't you go get their business? The reality is that that's, as you can see from the discussion, most of what we do at my firm is on the corporate side or with complex issues that don't really have a whole lot to do with some of the celebrity cases that you read about. But they do, you know, everybody has a reputation, and they want to protect that reputation. And they have to do an analysis as to whether to proceed and how to proceed to protect that reputation. And then you get to the tactics. And then you get to the press releases, and then you get to the statements, and you get to messages. And all of this, what you look at doing is taking the voluminous information about any legal issue and finding a way to put that in the right package so that it's understandable by the media, by the public, by regulators, by politicians, and ultimately at times by judge and jury. Although the other part of this I should mention is that juries really have very little to do with the work I do day to day because, as I said, most cases settle. You know, and the ones that don't, by the way, in the civil context, a lot of those are tried before judges where the judge is the ultimate trier of fact and there is no jury. So there is this other misconception that somehow you're trying to influence judge and jury, and I think that it's less true than you might think simply because things don't wind up in a Law and Order style trial. So all of this is part of the practice of law, particularly in this media age. And, you know, there's no sense denying that everyone is influenced by all of these extrajudicial forces, including, by the way, judges. We just worked on a case where the goal over the course of a year was to present the proper public face to a case that had been lost so that when it got to the Court of Appeals, the judges on the Court of Appeals and their clerks, by the way, who are much younger and more media savvy, had the right frame of reference when considering the issues on appeal. You know, when you lose a case at the trial level, you know, a lawyer once told me that the appeals court is where the law catches up with the headlines. You know, I think that when you lose a case at the trial level, you get a lot of bad news. It's natural to assume, and in fact the reality is, some of that is going to filter to the next level of the court system. You know, we can't, everything we do as a society, and particularly in the media age, has removed the blinders from around our eyes, and yet in some sense we assume that the judicial system, and particularly judges, keep those blinders on, and it's just not true. I mean, I remember, you know, increasingly it's the attorney's job to do all this as well. You know, and I remember a quote from a case that occurred in 1991, a Supreme Court case. The Supreme Court more or less validated the attorney's role in managing some of these impacts. The case was Justice Kennedy in the case of Gentile v. State Bar of Nevada, where he wrote, "An attorney's duties do not begin inside the courtroom door. He or she cannot ignore the practical implications of a legal proceeding. An attorney can take reasonable steps to defend a client's reputation and reduce the adverse consequences of an indictment. A defense attorney may pursue lawful strategies to obtain the dismissal of an indictment, reduction of charges, including an attempt to demonstrate in the court of public opinion that the client does not deserve to be tried." And, you know, that's from a Supreme Court case in 1991, you know, long before the O.J. Simpson case, long before the explosion of media, both traditional and non-traditional. And, you know, media now infiltrates all aspects of our lives, and it has an enormous impact on every step of the judicial process. what is interesting is that even district attorneys and U.S. attorneys are impacted by the way cases will be perceived. If they believe, and I can tell you this from experience, if they believe that they have a target that's going to fold, that's going to make some great headlines, that's going to produce a number that makes their bosses happy, they're much more likely to go after that person, even in the criminal context. And I think back to, Barry Bonds is on trial now. I think back to the Bonds indictment and how everyone was surprised by it. He had been under investigation for a very long time. And then I think it was towards the end of 2007, really right in November, before Thanksgiving, he was indicted. And everyone was shocked. And couldn't figure out why, after all this time, he suddenly had been indicted. And by the way, the indictment didn't say a whole lot. Well, it turned out, a number of things had happened, and the PR guy in me immediately kind of saw them. One is the World Series had just ended, and there was no more baseball news to get in the way of the big news of Barry Bonds being indicted. In addition, if you waited a few more weeks, Thanksgiving and the Christmas holiday was there, and there'd be too many stories about, what shoppers are going to do this holiday season to get in the way of a big story. And the U.S. attorney who filed the indictment and had been investigating the case for years was leaving the office at the beginning of the new year. So it wasn't necessarily the facts and the law that caused the indictment to be brought at that point. It was the timing and the motives of the U.S. attorney that did. And you see that in cases all the time. And I encourage you, as you see an indictment, as you see a lawsuit being filed, to really look at those sorts of things. One interesting thing to do is watch how much bad news comes out in the last week of August, or in that holiday period between Thanksgiving and Christmas. If you take a close look, you'll see a lot of companies announcing bad things because they know that people are either on vacation or they're gearing up for the holidays and not paying attention. And watch how many smart prosecutors announce things on a Monday or a Tuesday rather than a Thursday or a Friday. Because if you make an announcement on a Monday and Tuesday, you have an entire week of news coverage. If you make it on a Thursday and Friday, everyone goes home for the weekend and the story's killed. It's hard sometimes to think about all this impacting the practice of law, but it really does. And your response, each step of the way, will form its own set of perceptions that can greatly influence everything that goes on. A friend of mine is Bill Ohlmeyer. I love telling the story. He was the lead attorney for Altria Corporation during all the tobacco wars. And in discussing the impact of perception, he put it like this. If your teenage daughter comes home one night, on a weeknight really late, and you ask, where have you been? And she says no comment and runs up the stairs, you're going to form some perceptions about what's going on. If she walks in and says, look, let me get back to you. What's your deadline? And runs up the stairs, you're also going to form some perceptions. If her response is, look, I made a mistake, I'm sorry, I'd like to talk about how we can prevent this from happening again, those two sentences are going to change the whole tenor of what goes on between a father and daughter. It sounds simple, and in a certain way it is, but it's oftentimes forgotten that these little messages and perceptions that you send out every step of the way can have an enormous impact over legal disputes. And it looks easy, but it's where the art and science of what I do comes in. And so everything you do can have an effect on every other actor in the litigation, particularly the other side. And again, in an era when so many cases settle, or are pled out, I suppose, in the criminal context, or a decision in the criminal context is made not to prosecute, which is a discretionary mood. in that age where so much is decided outside the courtroom, how everyone is perceiving what's going on just has a natural impact. And lawyers and prosecutors and judges, for better or worse, and the general public, they tend to believe what they read. And we certainly know politicians believe what they read as well. You know, so this doesn't mean, by the way, calling a press conference at the drop of a hat or issuing a statement for everything that happens. I mean, that's something that can cause you more problems than it solves. It's not about generating the most media possible for your case or your cause. It's about generating the right media. You know, during the, I worked on a case a number of years ago involving some internet companies who were used to, you know, issuing a press release for every positive thing that happened in their business. You know, they got a new investor, they issued a press release. You know, their product went from version 1.0 to version 1.1, they issued a press release. So they were involved in this patent lawsuit, and the judge issued continuance because one side had a scheduling conflict. And you know, they asked for a continuance, and the judge granted it, and they issued a press release saying, "Judge rules in our favor in lawsuit." You know, the most routine ruling on earth. It went all over what's called PR Newswire, Business Wire, which is the paid wire services, and everyone saw it, including, by the way, the judge, who was not very happy the next time he saw that party in court. And so you can shoot yourself in the foot if you think that everything, that if you just, you know, there's this kind of notion that everything's a soundbite and everything is repetition. But you can shoot yourself in the foot if you do things without thought during the litigation communications process. And everything that a litigant does, as I say, has an impact on how they're going to be perceived and how they act. And I'll give you one more example, and then I'll open it up to questions, because I love taking questions which develop some of these ideas. I mean, I worked on a case about a year ago. This will give you some of the practical aspects of what happens in the courtroom. Healthcare case, a very good case. You know, it was a very worthwhile cause, and they seemed to be right on the law, the party. The side I was working for asked for a preliminary injunction to stop the other side from taking certain action. It's a very difficult thing to win, a preliminary injunction under any circumstances. My client, in the hearing for this preliminary injunction, it became clear very quickly that they were losing, and they were losing big. You know, I think the judge said something like, "I'm inclined to rule against you, but I'll hear your argument anyway, see if you can change my mind." I mean, it was, and it went downhill from there. It was not going well. A very good case, but not a very good day. You know, the problem is a lot of people were watching this case, and it was a big media day for the case. In fact, I remember, I generally during these cases sit in the gallery, and I had two very prominent nonprofit executives sitting with me who were sympathetic to our case and hoping for the best. And it was clear that things were just going down the toilet, for lack of a better term. You know, there were reporters throughout the gallery as well watching this happening, and there were several news cameras, 3 news cameras set up at various points outside the courthouse door, waiting to interview people when they came out. So it's only a small portion of the case, but it was a big day for the media. And it was a mess. I mean, the lawyers from our side were really feeling the heat, and they were getting red-faced. They were sweating. You know, they were really wilting under the pressure. In addition, our lead attorney was also had a reputation as being a hothead, who would just fly off the handle and say anything he wanted to in any circumstance. So the big fear was he was going to burst out the door and either say something stupid to the cameras when he got out there, or just knock a cameraman over, you know, and put his hand over the camera lens. So we had a bad ruling coming. We had to figure out how to minimize today's damage so that it wouldn't impact the overall perceptions of the case. And so we did 2 things. One is went around to the print reporters in the room and said, look, we're not going to make when this all ends, we're not going to make a statement to the media, but within 20 minutes we'll have a written statement for you that you can use in your coverage. And then I spoke to the two nonprofit executives who were not connected to the case but were well known, and I really asked them if they could help out. And so what happened was, with those 3 television cameras outside, I knew that the other side's attorney, who was, not shy either, and was winning big, the minute he burst out of the courtroom door, he'd run to the first camera. And so I knew that camera would be occupied, and I asked the 2 nonprofit executives, look, as soon as this is over, can you walk out and immediately begin to give an interview to each of these television news crews? Explain how hard it is to get a preliminary injunction in these cases. Explain that this is only the first round of a very worthwhile fight. Explain that to claim victory now would be like calling a baseball game at the end of the first inning. And so as the 3 video crews were occupied, I quickly grabbed the legal team and ushered them out into a waiting car, got them away from the courthouse and back into their offices. We later issued a written statement that had all the elements of what I just told you in it, and came from the very attorney who would have knocked a cameraman over 15 minutes earlier. And so, as a result, there's no hand over the camera lens. There's no off-the-cuff statement that will damage the case down the road and make people believe that, hey, this case is actually a loser. There's no visual of an angry and beaten legal team staggering out of the courtroom to their waiting cars that you see so often. And again, like the story of the 14-year-old girl and her father, a well-chosen response takes a potentially disastrous situation and makes it manageable. And that has nothing to do with legal strategy. It has nothing to do with the facts of the case. It has nothing to do with an overt effort to spin perceptions. What it has to do is really taking the information available and presenting it in a way that gets you the desired result. In this case, managing a small part of a case that could have been disastrous in the long term. And so finally, I'll wind up with the sort of point that people wonder about a lot, which is the ethics of it all. Is this fair? Because of these outside influences, does justice ultimately suffer? Do vicious, amoral spin doctors kind of use their black magic to convince everyone that down is up and white is black? Do they tilt the scales of justice unfairly? Or do they allow waves of public passion that swell in the wake of a media barrage to overwhelm a dispassionate dispensation of justice? I actually believe the opposite is true. That properly using these channels evens the playing field, eliminating many of the advantages that had traditionally been out there in the legal system, including money, ideology, influence, and class. The major, over the history and certainly over the recent history of our judicial system, the major element that has allowed you to win or lose a case has been money. And I think that if you look back at the O.J. Simpson case, I don't think it was necessarily a case of spinning the media that got him off that first time around. He was able to hire more expensive lawyers and experts to muddy the waters against prosecutors who were on public salaries and had limited resources. And guess what? The money won. And interestingly enough, it's only when he ran out of money that he wound up in jail, because he couldn't afford the so-called dream team. I think that new technology has also allowed a scalability of information that also levels the playing field. It's no longer the case that a defendant can look at a plaintiff and say, you know what, we can drag this thing out for years. They'll never be able to defend us, because there's this other element that is easily accessible and usable to even the playing field. I think that over the years there has certainly been extrajudicial forces that impact justice and impact the process of law. Media now is probably the most dominant force in our culture. Why wouldn't it take its place alongside the others? And I think ultimately, there will always be bad actors. There will always be bad guys out there who bend things to their own ends. But on the whole, I think it has an entirely positive effect on both the practice of law and the administration of justice. And with that, I'll take questions and get into some specifics for anyone who has them. Wow. I guess I answered everything. Go ahead, sir.
If I could return to David Boies in the NFL.
Sure.
Do you believe that the NFL would be wiser in having maybe an expert in labor law, someone perhaps not with the name of David Boies, someone less well-known, but someone who's really an expert in labor law?
Well, in that particular case, I will tell you this, and it's not to besmirch his credentials at all, but this is actually an antitrust case that he's arguing before, and that is his specialty, and he's considered the best in the world, I suppose, at that, going back to, I think he worked on the original IBM cases in the 1970s, and then Microsoft. So it is exactly his area of expertise. I just think that there are a lot of good antitrust lawyers out there. I think that there's an added element to his toolkit in which, when he talks, people listen. Your arguments tend to get heard. The validity of your arguments take on a new resonance that maybe don't take on if the person is not as well known. And there's this very interesting trend in big law firms that are developing these star lawyers, and they're paying them millions of dollars, $5 million, $6 million, because they're the name. And clients want a name. There's a growing star system among litigators, at which I'd say he's at the top. And so I don't know would they be better suited to having a hands-on nuts and bolts litigator as opposed to David Boies? Depends on what you're trying to accomplish. I mean, I think that in that particular case, we were discussing this over lunch, it's all public posturing. The lawsuit that was filed by the players would take 4 to 5 years to resolve if it went through. The average NFL player's career is 4 to 5 years. That case is never going to be decided. Each side is engaging in its own public posturing, and eventually they're going to wind up settling, and I imagine they're going to wind up settling for about what they could have at the beginning of the process.
Could I
Please.
maybe ask the question perhaps a little differently? Based on what you just said, are there instances, maybe you can cite one or two, maybe high-profile cases where the attorney who's involved is a star attorney or a high-profile attorney, rather than someone who might be an expert in that particular field? The parties would have been better served to engage that attorney or another attorney who's in high profile.
It's hard because in any large-scale litigation, whether it's high profile or not, there's always the star partner, and then there's the 4 or 5 partners and associates who do the actual work. And in this case, there are those types as well. So I don't think it's a case of, there have been cases where an attorney has shown up unprepared because the name was drawn, and screwed things up. But those are kind of few and far between, I would say. Yes, sir.
Jim, why does the media listen to you? I mean, they know you're a PR professional. Maybe they think of you as someone who's just a spin doctor. I mean, you describe a situation where you said, I can prepare a statement for you guys to use. Why don't they just take your statement and just wad it up?
Well, look, in talking about manipulating the media, one of the things you have to remember is what we do is not manipulation, but giving reporters what they need and giving the media what it needs to write the story. I think that if you do that, and I'll tell you, if a reporter believes that you're full of crap, or that your stuff is nonsense, or it's unusable, they just won't use it. If they begin to understand that, when I deal with this person, they have a side, they're advocating, but they're generally telling the truth. They understand my needs, my deadlines, what makes a good story, and they're going to get me that, and that's going to help me do my job. You know, and that they don't engage in kind of overt evil, in sort of saying that black is white and white is black. They're going to start relying on you for that information, because reporters have enormously difficult jobs to do. I mean, they're the first, you know, they often say that it's the first draft of history, news reports. You know, they have to take all of this information, put it into a form that their readers can read in shorter and shorter, you know, 400 to 500 words is the average news report these days. They have to put all of that information together in a way that is understandable, that tells the truth, and that fits within that news hall. You know, and they have to do it, I mean, it used to be you'd say they have to do it by 4 p.m. or 5 p.m. And now we're in a 24-hour news cycle, and even the New York Times, when you ask them their deadline, they'll say, well, my deadline's as soon as I can post this, because they're posting stories throughout the day on the internet. So it's an enormously difficult job, and one of the things in my business you do is you make their job easier, you know, and you become sort of a trusted, I mean, no one ever, it's a trusted relationship between a reporter and a PR person can only go so far. I mean, they understand that you're representing a client, and you're doing a certain amount of you're putting your facts in the best light. But they will, if you become someone who they understand can get the information to them that they need to do their job, they'll help you out. Yes, sir.
Typically, when in the process, firms like yours brought in, I have a perception that it's probably too late. And secondly, then how long does it take you to get up to speed? As you mentioned earlier, there are a multitude of documents that you often cover.
It is, you know, we're often brought in at the last minute, and still in this, you know, it's changing perhaps slightly, but still it's very much after the first reporter has called and the legal team started thinking, oh my gosh, I can't believe that 60 Minutes called us on this. What are we going to do? You know, I've been hired on the spot at times. In one instance, when a camera crew was actually in the company's facilities, you know, and I didn't even know who the client was to work. So it's very late in the process, and it's an enormous task to get up to speed because, again, it's not. I can probably get up to speed on a Lindsay Lohan case and a Charlie Sheen case fairly quickly. You know, a patent case or something involving a federal investigation of a healthcare company for self-referral kickbacks, you know, it takes a little work, and you really, part of the skill is to take that voluminous information and know where to go to find the story that can then be put in the right form. Yes?
I just wanted you to kind of elaborate on an idea that you brought up that I thought was interesting, this idea that using social media as a tool in litigation can really kind of help level the playing field for economically, socially, clients who typically are disadvantaged in that regard. I mean, I just kind of, I guess to me it just seems like you're throwing money into a different area. I know
Yeah, no.
tends to be cheap.
Well, yeah.
Still not cheap.
Exactly. I often tell my clients that I'm still not cheap. But, you know, it is very, I mean, the average, you know, in a high-profile piece of litigation, you know, spending $1 million a month is no big deal. I mean, it's, you know, it's par for the course because there's so much you have to do. You know, plaintiffs are constrained by their level of resources, and their lawyers are constrained by their level of resources. You know, in the old days, the trick would be if you were, for example, a tobacco company and the plaintiff's lawyers were suing you, you'd back a truck up onto their front lawn with 500,000 documents and dump it on the lawn and say, go ahead, find the incriminating evidence in that. And by the way, you have 2 weeks to do so. I mean, everything is now available electronically. The ability to communicate with outside audiences is something that can be done electronically through, I mean, you look at Twitter now. Twitter has actually become kind of this newfangled Associated Press for real-time. You know, it used to be back in the days when I was a college radio reporter, we had that jangling newswire machine working all day. And when urgent news would happen, you'd first get something that looked an awful lot like a Twitter feed does nowadays. You know, a quick one sentence, more to come, you know, at the end of it. it's remarkable the way media is changing, and the scalability of anybody's thoughts. Now, there's a downside to that, and that there's a lot of silliness that gets distributed as a result, and so you still have a filtering process. But the ability to get out there and tell your side of the story is just that much greater than it had been. Yes.
Going back to when you were talking about like having a reputation that's trusted, or like giving the media something they can use, those kinds of things. How far does that go in helping what your firm does? Because like you were in the lunch talking about like people who have like more shady tactics or threatening tactics.
Yeah.
They tend to be high paid as well. So how do you balance their tactics versus yours, and having trust from important members of the media that
Well, I mean, it's very, at lunch I was talking about that you know, there tends to be, there's a type of PR person out there that everything is a sly move, an angry threat, you know, dropping information on someone, smearing them. You know, I know one PR guy who tells clients that he's going to put people on a wheel of pain and start stretching it till the other side gives in. You know, and a lot of that is macho posturing. And I'll tell you, I've come up against those firms, and we tend to beat them every time because their defenses are, their attack is easily taken apart. And I told a story that there's a particular PR firm that every time they get engaged by a client, they send a letter to the media saying, I want you to know that I've been engaged by this client, and I was a journalist for years and years, and I have journalists here from the Wall Street Journal, New York Times. We know your ethical standards and what you have to do, and if you write anything that we don't like, we're going to immediately come after you. And he sends that out every time. And you know, I've been on the other side of a lot of cases when that happens. And I did a little checking, and it turns out he had been a reporter in college for about 2 weeks. You know, and all I have to do now is call up the media that gets that letter and say, look, you know, don't believe this nonsense. He does it every time, and he was a reporter in college, and, you know, he's got the former, you know, janitor from the Wall Street Journal working with him. You know, all of that, everything is a battle between reasonable and unreasonable. And reporters, as they do this enormously difficult job, their antenna goes up for certain things. And if you can just come off as a reasonable, if biased, purveyor of information that they can use, you have an enormous leg up. And it's not the other thing that happens a lot is who do you know syndrome, which is you get hired by clients. And, you know, I want something in the New York Times, who do you know? Now, I know a lot of reporters in the New York Times and the Wall Street Journal. I got to tell you, they all hang up on me if I don't have a story worth telling. You know, conversely, if I have a story worth telling, I can get to anybody. You know, so long as, you know, I come across as I say, a reasonable, if biased, presenter of information. Yes, sir.
I get the feeling that a lot of your business is already with newsworthy issues, like you say. But, and then you said something now that made me think of what one of the students suggested before. It seems to me there are billions of stories, and or millions of stories. I hear from police people in cities that, you know, there are 40 murders a day. You may get one of them.
Oh, yeah.
How much of your business is finding out something that really needs to be told, and raising it from the level of not newsworthy or not perceived as newsworthy, and making it newsworthy?
Well, the second part of that is not perceived as newsworthy. There's this amazing filtering process that winds up with what you read and see in places. And there are an enormous number of things that are newsworthy that you never hear about, never see, because it just didn't attract attention. And particularly in a lawsuit when there's, and particularly in a lawsuit like the type we work on, when there's so much going on in the case, and so many facts, so many issues, so many documents. You know, a lot of times it scares me to death when I work with attorneys and they say, oh yeah, I just sent over, you know, or I want to get a reporter interested in the story, I just sent over all the pleadings. And I imagine this reporter trying to bang out a story, and a set of documents this high winds up on their desk. They're never going to get the story from that, and you're never going to get the story in the New York Times. I mean, what you have to do is really sift through the information to find the nuggets that fit into a particular story. I'll give you an example. I worked on what turned out to be the largest single-family Holocaust restitution claim in history. This started around 2001, I believe. We started working with them, maybe a little bit before. You know, it was a very interesting story, but if you looked at the media, there were dozens of Holocaust restitution claims being asserted at the time. And the question was, well, what differentiates this one? And we started to look at it. This particular case included the land that Hitler's bunker was built on, and the Reich Chancellery and other prime properties in downtown Berlin that had amazing historical significance. Had nothing to do with the legal issues in the case, but it certainly helped to make that more of a story. And I think in everything, in most stories, you can look at things and find what would be of interest to the audience you're trying to reach. And we always say media, but in this day and age, it's really the end audience that you're looking at.
We have time for one more question. And answer.
Oh, of course.
Then I will ask the last question.
Oh, please.
There's, you say that part of your case for why this is ethical or just is that there have always been extrajudicial forces, and the presence of this media influence, which is now very accessible and scalable, levels the playing field. So do you think it's always been the case that whether the legal system produces justice or not has nothing to do with what's going on inside the legal system? It's always just the extrajudicial factors that array around it, so that there's no integrity to the process, the system itself. It's just a matter of all these forces. I guess another way of putting this is that it seems as if near the end you're presenting the legal system as the tail being wagged by different dogs. Now the dog that's doing some of the wagging is the media, and that's a friendly dog. Here, boy, friendly dog.
Well,
as opposed to the money dog,
yeah.
or the who's in my private club dog.
Right. And I don't know if I'd say the media is necessarily a friendly dog. Just
okay, well,
friendly. Just don't put your hand too close to its mouth.
Right.
But I think that I think that there has always been, within the integrity of the legal system, there's always been these extrajudicial forces that impact what happens, and I don't think it necessarily eliminates the integrity entirely. And I don't think certainly 50 years ago, 100 years ago, there were forces impacting. A lot of them had to do with money, race, gender, and class. And a lot of that worked its way into determinations of who got arrested and who didn't. Who got sued and who didn't. How things were ultimately resolved. Some of that still exists. But I think that media has taken its place. I think it scares a lot of people who had access to all of those things in the past, that media has now taken its place because it's something they don't understand and can't control as well.
Thank you.
Great.